Bharatiya Nyaya Sanhita. At the outset, it's very draconian. This is anti-national, unconstitutional. The people of India should fight. They should take this to street. Otherwise, any struggle protect their personal interest, social interest, political interest, rights would be curtailed by pressing this draconian law against them.
मिल्ली डाइजेस्ट में आपका खैर मकदम है। मैं मुबारक उमरी। नाजरीन, 1 जुलाई यानी आज से मुल्क में जारी होने वाले नए ताज़री कवानीन के खिलाफ मुल्क भर में एहतजाज हो रहा है। इन कवानीन के खिलाफ आवाज़ उठाने वालों में ज़्यादातर कानूनदान, लॉयर्स और जजेस पेश हैं। गुज़िश्ता 10 सालों में पार्लियामेंट में बिलों को जिस तरह पेश करके पास करवाया गया, वो इस बात को जाहिर करता है कि पार्लियामेंट में उन्हें पेश किया जाना सिर्फ रस्मी अदायगी के अलावा कुछ नहीं था। मुल्क के पूरे कोर्ट्स का निज़ाम बुनियादी तौर पर आईपीसी, सीआरपीसी और इंडियन एविडेंस एक्ट पर चलता है। अचानक हुकूमत को ख्याल आया कि ये कवानीन तो अंग्रेजों के दौर के हैं। बस फिर क्या था, इसे इस असर से पाक करने के लिए मार्च 2020 में, उस वक्त जब पूरा मुल्क कोरोना की वबा और लॉकडाउन से जूझ रहा था, नेशनल लॉ यूनिवर्सिटी के वाइस चेयरमैन की क़यादत में एक कमेटी तश्कील दी गई। फरवरी 2022 में उसने अपनी तजावीज़ात के साथ रिपोर्ट पेश की और 11 अगस्त 2023 को वज़ीर दाखिला अमित शाह ने नए कवानीन को भारतीय मुतबादिल के तौर पर पेश किया। पार्लियामेंट में वाज़े अक्सरियत का फ़ायदा उठाते हुए उन्हें अपने मखसूस अंदाज में किसी बहसो मुबाहसे के बगैर आनन फानन पास भी करवा लिया गया। इतने अहम कवानीन किस तरह मंजूर कराए गए, इसका अंदाज़ा इस हकीकत से लगाया जा सकता है कि जिस वक्त ये तीनों बिल पार्लियामेंट के दोनों ऐवानों में मंजूर करवाए गए, उस वक्त अपोजिशन के 143 अराकीन सस्पेंड थे। ऐसा पहली बार हुआ था कि बैक वक्त इतने अराकीन पार्लियामेंट को मुअत्तल किया गया हो, यानी ज़रूरी सलाह व मशवरा और गौर खौस के बगैर तीनों कवानीन पास करा लिए गए और अब उन्हें नाफिज किया जा चुका है। ये नए क्रिमिनल लॉज क्या हैं और आम इंसान की ज़िंदगी में ये कैसे असरअंदाज हो सकते हैं, इस पर मुकम्मल तफसील से मिल्ली डाइजेस्ट से बात की कर्नाटका हाई कोर्ट के लॉयर एडवोकेट एस बालन ने। वीडियो को मुकम्मल देखें ताकि आपको इन नए कानूनों के बारे में मालूमात मिल सके और दोस्तों अहबाब के साथ भी इस वीडियो को शेयर करें।
See, today is July 1st. It is in the press, it is everywhere that the government of India revamped, rebooted, and changed the entire colonial law, and it is a Indianization of law. If you read the tenor tone, the way it is drafted, a prima facie irresistible conclusion that could be drawn is that it's just nothing but old wine in the new bottle. I mean to say, old wine in a poisonous bottle. Nothing is new. It's just old. It's a cut and paste. It is copy paste. See, Indian Penal Code was drafted by Thomas Macaulay at the instance of East India Company in the year 1816. He spent many days to draft Indian Penal Code. In the year 1872, James Stephen, he drafted Indian Evidence Act, and the same year, Criminal Procedure Code was also drafted. It is time tested. There was change in the world scenario due to the introduction of John Maynard Keynes' concept of welfare society. Therefore, several amendments were brought into these three laws. When India achieved independence, Dr. Ambedkar drafted various protective measures to the people of India. Article 14, equality before law. Fundamental right, Article 19, 20, Class 3, nobody can be a witness against himself. No confessional statement. Article 22, fair justice. So this is also drawn from international covenants. Universal Declaration of Human Rights, European Covenants on Human Rights, international political and civil rights. That is also taken into consideration, and our criminal justice system was in consonance with the principles of constitution and the various covenants of international justice system. That's how Indian criminal justice system was brought on record. Various high courts, including Supreme Court, set addressed various grey areas left in the act by way of judicial pronounced judgments, time tested. All of a sudden, the present ruling dispensation made a drastic attempt to revamp, reboot, to change, destroy the entire time tested law, and they brought this new system, the new criminal laws. So, who is the stakeholder? When 1973 Criminal Procedure Code was amended, see, the task was given to 41st Law Commission of India. It is the Law Commission of India bestowed with the power of amending, deleting, inserting laws. This time, Law Commission was kept away. No discussion in the parliament, neither in Lok Sabha nor in Rajya Sabha. Who are the other stakeholders? Supreme Court Bar Association. Then Bar Council of India, Bar Council of respective states. No lawyer was taken into consideration for the purpose of amendment. Then who are the sufferers? People of India. Minorities were not taken into consideration. Adivasis, Dalits, backward class, workers. Then who was responsible for amending this law? It was Raghubir Singh, a vice chancellor of Delhi Law University, a registrar of Law University, a lecturer of Law University, a retired judge, and a practicing advocate. All five are affiliated to a ruling dispensation political party. They were given the task of rewriting all these laws. And what now they name it as Bharatiya Sakshya Adhiniyam, Bharatiya Nyaya Sanhita, Bharatiya Suraksha Nagarika Sanhita. What language is this? Whether it's Kannada, Urdu, English, what language is this? This is the language of Jyotishta. Jyotishta, it's a divine language, not the people language. Why should they name this? I oppose to this. This is opposed to the principles of constitution. I oppose this. Then why stakeholders are not consulted? We have to oppose this. Okay, this is the law. So whether it is decolonization, no, it is inhumanization. Why I say this inhumanization? See, either two, the law was police custody was only 15 days, initial 15 days, not thereafter. Now up to 40 days, 60 days, 90 days, repeatedly the accused can be taken to police custody. This is permitting the investigating agency to fabricate evidence against a person, a Indian. Then it's not fair justice. The presumption is in favor of the state in respect of the offence punishable under section 146 to 156 of the Bharatiya Nyaya Sanhita. So the presumption, the moment case is registered, he is guilty, and it is for the accused to prove that he is not guilty. So reverse burden. then confession before the police is admissible in evidence under 22 of Bharatiya Sakshya Adhiniyam. Proviso A and B says that any confession before police officer is admissible in evidence. This is very, very dangerous. Indian Evidence Act, section 25 and 26 of Evidence Act indicates that no statement made before the police is admissible in evidence. So again, power is given to the police. See, any case, the investigation totally defense are in the domain of investigating agency. They register an FIR, then they investigate. Try to create a chain of link of evidence. Everything should be in the form of Panchanama. Now ample power is given to the police to fabricate, manufacture evidence against the targeted people who may be minority or Adivasi, Dalits or a worker or agriculturalist. So, sufficient opportunity is given to the police for fabricating, manufacturing evidence. Once it comes to the court, then power is bestowed on the prosecution to get or elucidate answers in their favor, because prosecution is bestowed with the power of leading questions. Either two, it is not admissible. Now the law says, even without the presence of the accused, the trial should go on. Even without the presence of the accused, the judgment can be given. This is most unacceptable. Digital evidence. See, any digital evidence can be manufactured, edited by cut and paste method. Either two, there are several judgments. 65B certificate, the procedure for it, and the 45A of all that is given a goodbye. Now it is only 63B of Bharatiya Sakshya Adhiniyam. So, investigation process, it is in favor of the state. Prosecution process in favor of the state. All defense mechanism, internationally accepted defense mechanism, is completely shut by amending various provisions of law. Therefore, it would definitely affect Adivasis who protest to protect their forest or hills, Dalits who wanted to protect their interest, workers who protect their interest. At the outset, any right-thinking people who wanted to protect national wealth, and they will be behind bars. Section 111 and 113 of Bharatiya Nyaya Sanhita bestows power upon the state to implicate anyone in the scheduled offence. That's the reason why UAP Act, Control of Organized Crime Act are brought within the purview of Bharatiya Nyaya Sanhita. At the outset, it's very draconian. This is anti-national, unconstitutional. The people of India should fight. They should take this to street. Otherwise, any struggle, protect their personal interest, social interest, political interest, rights would be curtailed by pressing this draconian law against them.